Well, good evening and welcome to those of you that are joining us here live. And to those of you that are watching this recording at a later date, we appreciate you being here with us as well. My name is Michael Gault. I'm an eminent domain lawyer with Bell, Carrington, Price, and Gregg. At Bell, Carrington, we have an eminent domain team that focuses on representing landowners across our practice areas in the Southeast, being the Carolinas, Georgia, Alabama, and Tennessee. But if you're here with us today, you know that we're specifically talking about the US 441 improvements. The 441 Improvements Project in Georgia is a massive project. This is a project that has been in the works for a number of years through development and design phases, and now into acquisition and even construction phases in some ports around some parts of the state. If you're familiar with this highway, which all of you presumably are, US 441 goes all the way from the northernmost boundary with Georgia and Tennessee all the way down to the Florida line. A massive project with nearly $1 billion budget, as evidenced by the DOT's own information. But again, if you're here with us today, you know that we're specifically talking about the 6.3 mile portion of US 441 that transverses Lawrence County. So a couple of things that we wanted to be able to offer you in this virtual town hall, and that's really just letting you know what we can offer as eminent domain attorneys, what your rights are as a landowner, and how we may be able to partner to make sure that your rights are protected. At the outset, I'll say that in order to construct a project like this, which is taking a road that is currently between 2 and 3 lanes, depending on which section you're in, and making it a 4-lane divided highway with a depressed grass median, naturally private property on either side of the current roadway will need to be taken by the government in order to construct this road project. GDOT, like any other state agency or governmental agency, has the power of what we call eminent domain. Eminent domain simply means the power of the government to take private property to complete a public purpose. In this case, the public purpose is served by the construction of a roadway. And so in order to be able to take that property, the government will likely use that power of eminent domain in order to be able to take the property needed for the project. Fortunately for you as landowners, you also have rights. Among the most important of those is the right to just compensation. And just compensation just means that even though the government can take your property, they have to compensate you fairly and adequately for what they're taking from you, along with the damages to the remainder of the property thereof. That's a lot of legalese, but more than anything, you have to be paid fairly for what the government takes from you. Certainly the government is never going to attempt to intentionally mislead landowners, but oftentimes the offers that are made to landowners as far as what they're prepared to compensate you for what they're taking from you fall short of what the property is actually worth. And those valuations are very complicated. There's no mathematical formula where somebody can plug in the number of acres or square footage that are taken and multiplied by a price per square foot or a price per acre and lay that out on the table. Each property is unique. You have to look at the use of the property. Is it commercial? Is it residential? Is it industrial? How close does the impact come to the structure that's there now? If it's vacant, were there intended uses for future plans for development on the property or redevelopment on the property? And that's sort of where we come in. At Bell Carrington, we have a team that focuses on representing landowners. Most of us exclusively represent landowners in cases just like this. And so we know the process and the procedure. We know the terminology, and many times we know the players involved on both sides. And so we're able to partner with our landowner clients to walk them through the eminent domain process from the time that they receive first contact from a condemning authority all the way through the potential settlement of the case, or even eventually through the condemnation process and at trial. And those are some words and some procedures that many of you are not familiar with, and that's natural. If you're a landowner, particularly in rural parts of the state, like me, you probably never had to deal with this before. And it's sometimes overwhelming for there to be a knock at the door, a governmental representative saying, hey, here we are, and here's what we're going to do to your property, sign on the line. That can be overwhelming. It can be confusing, and we would never recommend anybody go through that alone. And so that's kind of why we step in to help our landowner clients and potential clients to navigate this process, to protect their rights, and ultimately to make sure that they receive the amount of just compensation due to them for the amount of property that they're losing. One important note that I'd like to mention is regarding attorney's fees. Sometimes landowners are hesitant to reach out to lawyers because they assume that there's going to be some massive retainer, a big hourly rate, and that the bill that they rack up at the end of the day may exceed whatever amount the government was prepared to offer them initially. And that's a fair concern. Fortunately, at Bell Carrington in our eminent domain practice, we work on a contingency fee basis. And that just means that our fee is a percentage of the amount that we're able to recover for you in the way of just compensation. It's difficult for me to be able to get into the intricacies of that fee arrangement because each parcel is different, and that structure can vary depending on the nature and the use of the parcel. But at the end of the video, we're going to give you some direct contact information to myself and to my team, and we're happy to have a consultation with you at any time to tell you exactly how those fees work. But you can rest assured that we will never ask you to come out of pocket to pay for any retainer, to pay for any attorney fee, and we don't bill you by the hour. So there'll be no out-of-pocket money owed from our clients in eminent domain cases. And we feel like that gives our landowner clients, particularly residential landowner clients, the peace of mind to know that we're on their side and that we're fighting the same fight, and we're not going to needlessly rack up a bill that ultimately goes against the intended goal, which is to make sure that you're fully compensated for what's taken from you. Like I mentioned, our consultations are always free. They're always no obligation. At Bell Carrington, we have a proprietary software that will let myself or a member of my team pull up your property in real time while we're on the phone together. I'll be able to see an aerial view of your property overlaid with a visualization of the impact to your property so that I can have an intelligent conversation with you to show what and to tell you what I think the actual impact may be. There's no way at the outset that I can talk numbers, talk offers, talk ultimate goals in a case like that, but we can look and say, generally speaking, this is a fairly minimal impact. I think we'll be able to work through this, or this is potentially a total take. You're looking at maybe losing your home in the worst case scenario, and that does happen, and it can happen, particularly in roads like this, in rural areas and residential areas where the homes may be built currently close to a 2-lane divided highway, 4-lane divided highway with a grass median. You can see where some of those homes may end up being a total take. But we can use that software while we're on the phone together to go over the impact of your parcel. We can further explain the fee arrangement to you to let you know how that works. And ultimately, hopefully, we can work on developing an additional relationship that could turn into an attorney-client relationship that will then allow us to give full legal advice about the impact to your property and to represent you from the inception of the project all the way through settlement. So finally, in a conclusion, I want to thank you for being here. This process, when it comes and when it presents you at your door, it can be overwhelming. It doesn't have to be. Our firm, and frankly, firms like ours, are standing by with folks who are experienced in representing landowners in eminent domain cases. We just want to make sure that at the end of the day, with whatever's taken from you, that you get paid fairly and adequately for that. And we invite you to reach out to us to see if we might be able to discuss a more appropriate or a more professional attorney-client relationship in the future. Again, Michael Gault on behalf of Bell Carrington, we appreciate you being here, and I hope to hear from you soon. Thanks.